This is Dave Pellegrinelli from TitleSearch.com. Quiet title actions have enjoyed increasing popularity in the last couple years. A quiet title action is a means to quiet or extinguish all or some claims against a property title. It's performed as a court case, normally in civil court, possibly in circuit court, depending on the jurisdiction. A property owner basically sues for quiet title, enjoining all third parties from ever making a claim of ownership, lien, mortgage, or any other action against the property. A case is presented to the court. The judge requires that certain conditions are met. For example, it may require notices sent to any potential claimants. It may require public advertisement of the quiet title action. And then time is allowed for potential claimants to bring their documentation. Could be 30 days, could be 60 days. Some parts of the country, it could be up to 2 or 3 months. So originally, a quiet title was used to resolve uncontested boundary disputes, or possibly when a company or another party is missing and can't be contacted to sign off on a release of lien or release of mortgage. The last couple years, quiet title have been used more often for foreclosure defense. And there's some advantages of why this method of foreclosure defense is popular. First of all, the quiet title occurs in civil court, which is a less lender-friendly venue than foreclosure court. When lenders are in front of a foreclosure judge, that judge sees lenders and borrowers all day long who are legitimately delinquent on mortgages. The lenders typically have prevail in those courts, where in a civil court, it may be a more even playing field for a borrower and a lender. At the same time, the action is brought by the borrower, by the homeowner, so the lender is now on defense instead of in foreclosure court, where the lender brings the action and the homeowner is on defense. There's also a time requirement. If in foreclosure court, the lender can drag out a foreclosure for months and months, sometimes more than a year. In quiet title, there's a statutory limit on how long the action has to take, so the claimant, the plaintiff, can get all their paperwork ready, submit it in court, and then the lender has only a certain amount of time to respond with correct paperwork. There are no do-overs if the lender's paperwork is not in order. The lender can't withdraw and then refile such as they can in foreclosure. Judges in civil court are more likely to be interested in the letter of the law, where mortgage note documentation is either technically correct or it's not. In foreclosure court, there are sometimes allowances for slight deviations from accepted title practices. Once a quiet title action is complete, the owner is given a final judgment of quiet title, which is recorded in the land records, enjoining all other claimants other than those listed on the quiet title from ever bringing claim against the property or against the property owner.